Hello everyone, this is Pridarshini Tiwari. I welcome you all in the lecture of Code of Civil Procedure 1908. So, the topic for today's discussion is Appeal against Preliminary Decree and the concept of second appeal. In our earlier lecture, we have discussed on the concepts of appeal and the concept of appeals against original decree. Now, in today's lecture, we will discuss the concepts of second appeal. So, before dealing in the concept of second appeal, I would first like to mention here the subtopics to be covered in today's lecture. So, today I will discuss about appeal against preliminary decree, appeal against finding, the concept of second appeal, the nature of second appeal, the scope of second appeal, the substantive question of law, and the question of law as to general importance. Now, the appeal against preliminary decree. Section 97 provides that the failure to appeal against a preliminary decree is a bar to raising any objection in the appeal against a final decree. It means if the party who considered himself aggrieved by the decision of any competent court fails to appeal against the preliminary decree, he is now precluded to appeal against the final decree. The court in the case of Subamma versus Subamma provides that the object of the section is that the questions which have been argued by the parties and declared by the court at the stage of the preliminary decree will not be open for relitigation at the stage of preparation of the final decree. It would be considered as finally decided if no appeal is preferred against it. The language of section 98 clause 2 is imperative and mandatory in terms. It talks about appeal against finding. The object appears to be then on a question of fact. In event of a difference of opinion, views expressed by the lower courts needs to be given primacy and confirmed. The appellate court cannot examine the correctness of the finding of facts and decide upon the correctness of either view. Now the concept of second appeal. Section 100 of Code of Civil Procedure 1908 talks about the concept of second appeal. As per Section 100 CPC 1908, an appeal shall lie to the High Court for the decision made by the District Court. An appeal lies if the decree is passed ex parte, if the High Court is satisfied that the substantial question of law is involved in, and it shall formulate the decisions. It is to be noted that the second appeal is on the ground of substantial question of law, not on finding error of facts. So, from the analysis of section 100 Code of Civil Procedure 1908, it is well clear that a second appeal shall always be laid before High Court, and it will lie only on the ground that it involves a substantial question of law. Now the nature of second appeal. The right to appeal is not inherited, but it is created by statute. The right to file suit is inherent in nature, but right to file an appeal is purely statutory right. This right starts from the date of filing suits. The decision of appellate court is final. The rights cannot be declared void until and unless declared by the statute. Now the scope of second appeal. The second appeal can be exercised only when the case falls under these categories. If it involves question of law, and such question of law should be substantial, and any other justification defined under section 100 of CPC. The question of fact wrongly determined should not be the criteria for second appeal. The term substantial question of law has not been defined anywhere under CPC, but it was first time interpreted by Supreme Court of India in the case of Sri Chunnilal Mehta Association Limited versus Century SPJ and Manufacture Limited. The proper test in case of determining the substantial question of law differs from our opinion and opinion of the court. In our opinion, it is of general public importance, or it affects the rights of parties, and also when decisions are not finally settled by the court or federal body, and in case wherein the court perceives that there involves a principle, then that principle to be applied when there is substantial question of law. So basically, substantial question of law means any question of law which has not been settled and determined by any higher court. Now the question of law as to general importance. The second appeal can only be filed when there involves a question of law, and question of law should be substantial. It is of general public importance, or if it affects the rights of parties substantially. Section 100 of Code of Civil Procedure 1908 also deals with the importance of the question of law. Clause 3 states the memorandum of appeal shall state the substantial question of law involved. By the virtue of section 100 clause 3, it can be said that the memorandum of appeal shall disclose that such appeal involves a substantial question of law. Clause 4 states that if the High Court is satisfied that it involves a substantial question of law, in that case it shall formulate such question. Thank you.